Welcome to this free immigration help channel. Today is June 7, 2023, and we are getting into the volume 111 of me answering your immigration related questions. As you can see, I have all your comments pulled up in front of me. As always, before beginning this video, I'm going to mention, as I mentioned in every video on this channel, I am not an immigration attorney. This is not a legal advice. All the information provided in these videos on this channel are directly from official government sources like USCIS and of course the Department of State with their visa bulletin. So let's start with the very first comment from GM. GM says, I lost my expired green card, but I have got 24 months extension letter. Can I travel back to USA with only the document of extension? Does it cause any delay at port of entry? GM, this is a very interesting question. So I would say it really depends on what kind of extension letter you're referring to. Because if you are renewing your green card, yes, you are receiving the approval notice saying that yes, your renewal application was approved. But then you are actually receiving the replacement physical card itself, so that you can present it at the port of entry when you are entering the United States, which is really what you should be trying to do, unless there is some kind of circumstances that I'm not aware of. If you have lost the expired green card, plus it's expired anyway, then of course you had to submit that renewal application, the I-90, which is the same as applying for a card. I'm gonna actually pull up this application on USCIS. So we're gonna go to forms. We're gonna go to all forms, and I'll just type in 90 here, and there you go. Application to replace permanent resident card. So if this is the application that you have submitted and you have received the approval letter saying that yes, your replacement card application was approved, then you should be receiving the actual card soon. If you don't have, if you can't wait for the actual physical card, then I am sure that you can figure out the way and enter a country by showing the letter, if there are some kind of special circumstances. But honestly, I would recommend waiting for the physical card itself, just because, well, one of the purposes of having the physical card is to show it at the port of entries in the United States of America. So take a look. Let me know if you can in a separate comment if this is what you're referring to, and I might be able to give you a little bit more information. But what I'm gonna do is I'm gonna put this right here, and I'm gonna put the link as well so that you don't have to search for it, for the application for the replacement of the permanent resident card. And let me copy this back. And we're going to move on to the next question from MC. MC says, how much revenue should the business in the US generate to maintain my L1A manager visa status? Is it like the E2 visa where we have to create some full-time employment within a couple of years? Thanks. MC, thank you very much for the question. This is an excellent question. Wow, today we are getting some very, I would say, complicated questions. So whenever it comes to the L1A, it is different from the investor visa, because in investor visa specifically you do have to show that you have enough capital, because you really are going into undeveloped areas, starting a business, and then obviously there you have to create the employment, you have to meet the certain requirements for the business. With L1A, it's not really exactly that, because they know that you're pretty much starting from scratch in the United States from scratch. So yes, you do have to have the documents to show that the existing company, foreign country that is outside of the United States, it is, well, USCIS calls it viable, right? Basically that it is working, it is operational, it's good to go, and it is in the position to send their manager or whoever to the United States of America so that they can establish an affiliate in the United States of America. So as long as your company can present that, that should be good enough. There is no minimum requirements, and in fact, I'm gonna actually go to USCIS once again. Might as well, use the website. So we're gonna type in L1A in the search, and I know they have a separate, yeah, there you go, intercompany transfer executive or manager. There you go. So the general qualifications. Let's see if maybe they changed something. This is, when was this updated? I don't think they show when. Oh no, there you go. So last updated May 4, 2021. So this is pretty recent. And the general qualifications: to qualify for L1 classification in this category, the employer must have a qualifying relationship with a foreign company. All right, makes sense. Currently be doing business as an employer in the United States and in at least one other country, directed or through a qualifying organization. Again, makes sense. Doing business means the regular, systematic, and continuous provisions of good. So you already know what you will have to show whenever it comes to doing business. To qualify, the named employee must also generally have been working for a qualifying organization abroad for one continuous year within the 3 years immediately preceding his or her admission to the United States. Again, makes sense. You're showing that you're not just some random person to this company, but you actually have an existing relationship with this company. That's why they're sending you as a representative to the US. Makes sense. Be seeking to enter the United States to provide service in an executive or managerial capacity for a branch of the same employer or one of its qualifying organizations. And that's really it. So you see the requirements, the qualifications are fairly vague. Vague, I think that's the word. I always pick the wrong words to describe what I'm trying to say, but I think you get the point now. So let me post this right here, and I'm gonna put the link as well, so you have that. And if you have any follow-up questions, don't hesitate to come back here on this channel and ask. And that goes for everyone. Just make sure, whoever, if you have any follow-up questions or comments, don't post your question or comment under my comment. Don't respond to my comment within your comment, because YouTube does not send me notifications for those. Please submit it as a separate comment. Okay, moving further to Anna Rocha. Sorry for mispronouncing the name, Anna. Anna says, hello, is there any news about the vaccine requirement? I really do not see anybody talking about it. Isn't this also part of everybody's dignity? To do with your body what you think is the right thing to do. Is anybody actually asking questions to the responsible people for immigration? Anna, thank you very much for bringing this up. I really, really appreciate it. I try, I do get, you're not the first one asking this, this question. I think it's a very, very valid question. To me personally, it is very valid, because I was never the proponent of, in general, going and doing all of these injections in general. Now, especially whenever it comes to stuff like flu, because to me, I trust God and the body that He gave me and the strength of the body that He gave me. We have immune system for a reason, and the more we're trying, it's a fact. You can check it. You can check it in science books or whatever. The more we're trying to protect ourselves from everything that is in the world, the weaker we become, and the more the world finds its way into our body, into our organism, stuff like this. It's the same thing with medications. It's the same thing with food. The more we process the food, the worse it becomes. The less nutritious it becomes, and the more harmful to our body it becomes. But again, this is a whole different, conversation that we can have for a very, very long time. And I'm completely fine. It doesn't bother me. It doesn't it doesn't affect me in pretty much any way. If somebody wants to live in the world as much and fully rely on medicine and processed food and the comforts of the materialistic world of the flesh, I'm completely fine with that. It's everybody's choice. But then again, at the bottom of it is everybody's choice. So the people that are that don't want to be as involved in the materialistic world of flesh, they have the choice. They should have the choice of not being involved. And unfortunately, with these mandates and requirements, which are unconstitutional, if you think about it, they are unrighteous. That's the important word. They are unrighteous. A lot of people are being forced, and a lot of people are giving up on their beliefs and on their faith, really, and are going and doing these things against their own will. They don't want to, but they go and do it for the sake of immigration status in a lot of ways, because this is immigration channel. So yes, there is still a requirement if you are applying for the adjustment of status, if you are applying for permanent residence. Yes, you have to go and you have to get the COVID shot. And it has been removed, the proof of vaccination has been removed for international travelers. It has been removed for everyone. If you go right now and apply for work somewhere, most likely they're not going to ask you for the proof of vaccination. Most likely, I don't know, unless you live in one of the very, one of those states that is not going to get into politics. But for some reason, the requirement for the COVID shot is still there for people that are applying for the adjustment of status, which makes absolutely no sense because most of these people are, most of them are already here in the United States. That's one of the weird things because they have been living, for example, asylees, refugees, a lot of times with I-130, spouses, most of the times they are here in the United States with their U.S. citizen or permanent resident spouses. And they have been living here for a while, waiting for the process to complete. And now they're at the final stage where it's just a matter of going and getting the immigrant visa or getting the permanent resident card, temporary permanent resident card. And in order to get it, they have to go through medical examination. And on medical examination, all of a sudden, there's a requirement to get not just COVID shot. And it's not just specifically against the COVID shot that I'm talking about. It's everything else that is on that, there's there's a lot of those shots that you have to take as part of the medical examination. And I had to take a lot of them because, I wanted to get my permanent residence. And a lot of people do them because they want to get their permanent residence. And yes, it is not right. It is... I wish that it wasn't there. And I encourage everyone to reach out to their local elected officials, senators, congressmen, whoever, state representatives. Reach out to them and let them know that you don't support this. This is not fair. It should be removed from the requirement. It makes absolutely no sense. If the person has been living in the United States already for the past 5 years, 10 years, and they're just now applying for permanent residence, what's the point of going through this and getting all these shots? And it makes absolutely no sense. So Anna, thank you very much for bringing this up. And everyone else, if you're watching, if you agree with this, then, don't just leave it on the back shelf. Make sure to reach out to your elected officials. Okay, moving further to straight to the point. Straight to the point says, hi, I petitioned for my wife in Ghana. Priority date is February 2021 and document qualified February 5th, 2023. What waiting time are we looking at based on the visa bulletin? So congratulations. Congratulations on becoming documentarily qualified. That's a huge milestone. It means really the only thing that's left is that medical examination that we were just talking about, and then the interview to get that immigrant visa. So there's two options, right? You're either a U.S. citizen or a permanent resident petitioning for a spouse, and that will be a little bit different. If you are a U.S. citizen, and I'm thinking you are because your application was processed pretty quickly, roughly about 2 years between the priority date and the documentary qualification, I would say probably you are a U.S. citizen petitioning for a spouse. Because if you were petitioning as a permanent resident, then you would be in F2A category, and then you would be dealing with the visa bulletin, which I don't know if you are dealing with it or not, but let's take a look first at the F2A. So right now is September 2020. So people with a priority date back in September 2020, as of right now, they're getting their immigrant visas, which is roughly 3 years. Yep, roughly a little bit more than 3 years. So 3 years and 3 months, roughly. In your situation, you have applied in February 21, and then pretty much exactly 2 years later, you already were documentarily qualified. So if you are a U.S. citizen, then you probably have another 6 months, maybe a little bit more to wait for the interview, waiting for the actual interview for immigrant visa, because the immigrant visa is already available. So the only thing that you are waiting for is the U.S. Embassy to schedule the appointment. However, If you are in F2A category, if you are a permanent resident petitioning for a spouse, F2A dealing with the visa bulletin, then we know that roughly there's a 3-year backlog, a little bit more than 3 years. So you're looking probably at another, well, it's February, so September, right now it's September 2020. So you're probably looking at another year, a little bit over a year. My math is not very good, but roughly about another year to wait for the availability of the immigrant visa. And then once it is available, then the U.S. Embassy schedules the, in Ghana, U.S. Embassy in Ghana schedules the immigrant interview. So if you want, let me know. Let me know if you are a U.S. citizen or permanent resident, because you see there is some difference between the two. In one, the immigrant visa is already available. In another one, you are waiting roughly another year, maybe a little bit more, because February and September, for the availability of the immigrant visa. And again, please don't respond to my comment within your comment. Please submit it as a separate comment so that YouTube sends me the notification for it. Okay, moving further to Kokui 82729. Kokui, thank you for being publicly subscribed. I really appreciate it. This is what this icon means. So Kakui says, hello, good day. I got documentary qualified April 6, 2023 at NVC. It's for my wife and the 2 kids, paid all the fees, but some reason the children's fees say unavailable. Do I have to pay them at the US Embassy in Santo Domingo the day of the interview, or do I make separate I-130 for them as they was added to the I-130 of my wife? Great question. So are the kids under 21? Because if the kids are under 21, that's it. You don't have to worry about anything. They will be going as derivative beneficiaries together with, with your wife. So that's it. You're good to go. There is no other fees that you would have to be paying at the embassy or anything like this. The only other fees that might come up later is for the actual physical permanent residence card. Once already everything is approved, once your wife and the kids get the immigrant visas and come into the United States, after some time, I think it's like 90 days, I think they say, the actual physical permanent resident cards in your situation comes in. Yeah, that's really the only thing that you will have to pay for. But other than that, that's really it. You shouldn't worry about anything else. Now, if the kids are over 21, then in that case, yes. So for over 21, you would have to submit a separate I-130 petition. It can be either you or it can be your wife after she gets her permanent resident card here in the United States, becomes a permanent resident. So it's really it. But if they're under 21, then that's it. Derivative beneficiaries. Alrighty, let's move on to the next question from Aydin Aydemir. Hi mate, my wife is Ukrainian and I am Turkish. The question is, can we join Uniting Ukraine program U4U and go to America together? Aydin, thank you very much for the question. That's a great question. In fact, today, I don't know, today some really good questions today. Okay, so yes, absolutely. Both of you can because your wife is Ukrainian, both of you can take the advantage of the U4U. However, the whole idea behind U4U is that somebody in the United States will have to sponsor both of you. So they would sponsor your wife, and then you would be as a derivative beneficiary, as a dependent. Well, not really dependent, a derivative beneficiary. I think that's the correct one in the petition. And I'm gonna actually show you, and I will do the same thing. I'll get the link. So we're gonna go to it's right there at the very front. You can't miss it, at the very middle. Uniting for Ukraine. So eligibility, and you see the beneficiary. Immediate family members in this process include the spouse or common law partner of a Ukrainian citizen. So that's going to be you right there. And then for the sponsor, literally, well, let's read it, because before it used to be literally anybody in the United States who is a US citizen, lawful permanent resident, non-immigrant in lawful status, even non-immigrants in lawful status. That is, who maintain the non-immigrant status and have not violated any of the terms or conditions of the non-immigrant status, asylees, refugees, or parolees, TPS holders, and beneficiaries of deferred action. So literally anybody in the United States can be the sponsor. So as long as you guys have the sponsor who's willing to fill out the I-134A for you guys, that's it. You should be good to go. So let me post this here, and I'm gonna put the link so that you have that. You probably already are familiar with this link, but just in case, so that you don't have to search for it. Alrighty, moving further to Azhar Ahmed. Sorry if I'm mispronouncing the name. Azhar, probably Azhar. I got my interview date after 6 months of qualifying documents confirmation. Mine is US citizen, applied for parents. Okay, so thank you, Azhar. I appreciate the update. So you guys see, for everyone, most of the times, if you are in the immediate relative category, which means that once your USCIS I-130 petition is approved with USCIS, that's it. The immigrant visa is already available. Once you're documentarily qualified, that's it. It means everything is good to go. The only thing is left is to schedule the interview so that you can do the medical examination and go for the interview and get that immigrant visa. Roughly, after becoming documentarily qualified, in most of the cases, 6 months, as you can see. Okay, moving further to Rizwan Khan. Sir, I missed to write you. I am rejected refugee living in detention camp outside USA. My cousin won't sponsor me. He's citizen of America. Can he sponsor me? Rizwan, thank you very much for clarifying this. Okay, so unfortunately, whenever it comes to cousins, they can't petition for you. The only relationship that is allowed is for US citizen to petition for US citizen to petition for spouse, children, whether over 21, under 21, married or unmarried, doesn't matter, brothers and sisters, and parents. All right, unfortunately, cousins, they can't petition, but I'm trying to think what they can do is they can send you an invitation. The cousin can send you an invitation for a non-immigrant visa visit. So that's an option you have if you want to, visit your cousin, and then I guess if you can find any other avenues through study or through work, finding an employer that is willing to sponsor you. But that's really it. As of right now, I don't really see any other options for you, because unfortunately cousins cannot petition, can't start the I-130 petition for another cousin. Okay, let's move on to the next one from Sok V Bowl. Sok says, how are you doing, brother? Sok, thank you very much for asking. I appreciate it. Hopefully you're fine. I always follow your YouTube channel for your presentation. Sok, I really appreciate it. Thank you very much for watching. This means a lot. Alrighty, moving further to Faiza Saeed. Priority date is 5th June 2017. Any updates for this year? Okay, Faiza. Okay, so Faiza commented on F2A. So F2A category, that's permanent residents petitioning for spouses, children. So 2017 priority date is a little bit long. So I am thinking, well, because F2A is September 20 and Faiza is June 2017, so it's like 3 years over. So Faiza, can you please clarify, are you in F2A category? Because if you are in F2A category, then you are already, even for Mexico, it takes less, because they're already processing 2018 and you're in 2017. So let me know, please, which category you're in, because F2A doesn't really make any sense. Please let me know in a separate comment. Let me know again the priority date so that I don't forget it. Let me know the, and that's for everyone. If you're asking me to do some estimates for you, I need to know the priority date, I need to know the category, and I need to know the chargeability area so that I can give you as accurate, rough estimates, but more or less accurate. Okay, moving further to Oracle. Oracle says, hello bro, you have been very helpful. Oracle, I'm glad my videos are helpful. I sent the wrong I-864W to NVC portal for my daughter. That's I mistakenly uploaded my son's I-864W to my daughter's account on the NVC portal. Please, who is this? How can I correct it so that I can upload the right I-864W? Thanks. And then Miriam says, scary, part of doing things alone. Okay, mistakes happen, you know, that's fine. At least you caught it. That's good. Honestly, the worst case that's gonna come out of this is it's just gonna delay stuff, because once NVC, whoever does the review, they open up, they see, okay, they should understand, like, okay, it's not a random person, it's the person on the application, just submitted under the wrong, under the wrong person. So here's the thing. If it is already locked, because you know how the NVC portal, you have all those documents, fields for documents that you can upload. Sounds like you can delete it, or maybe it's already locked. If it's not locked, and if you cannot delete it, just upload the correct one there, and then upload the, so right now you have, let's see, for my daughter, so you send the wrong, so for your daughter, you submitted your son's. So for your daughter, if you can add additional document, add the correct I-864W for your daughter, and then for your son's, upload it again just for your son so that it's there. And then whoever is reviewing the information, they will figure it out. I'm sure they will figure it out. Or if it's already locked and you cannot, manually do anything yourself, then submit a public inquiry and let them know so that they unlock it again or delete it from there, so that you can upload the correct one. Just tell them that you have uploaded the incorrect one. And I'm sure you remember how to do the public inquiry form, but I'll actually find the link for you and then I'll add it to my comments. So I'm not gonna do this very quickly. Let's see. There you go. All right, perfect. So let me do this, and I'll put the link. And that's not gonna be a problem for them. They'll just unlock it or delete it. Honestly, if you just ask them to unlock it, that would be better instead of asking them to delete it, because you don't want them to delete something that you don't want to be deleted. don't put too much trust in them. All right, let's move on to the next one from Janena Simpson. My mom is under my household income. She doesn't work. We are a total of 7. Can she still ask for a fee waiver? Thanks. Janena, excellent question. Yes, absolutely. In fact, I would say she should ask for a fee waiver. Be prepared for her to provide some corroborating evidence showing that that she's not working, that she's retired, and some documents indicating the maybe the income that she's receiving from I don't know, like Social Security Administration or something along those lines, that show that the person is basically already retired, and it should be definitely good enough for the fee waiver. Alrighty, so let me put response, and we're gonna move on to the next question from Mr. Sam. I don't know why I said Dr. Sam. Mr. Sam, do you need to attach asset proof in financial hardship like bank statement? Mr. Sam, okay, great question. Again, on I-91912. So, yes, absolutely, you do need to. It's not really an asset proof that you need to provide, but more so showing the income, and that the income is obviously lower than the poverty guidelines or whatever it is based on you are applying for, the financial hardship. So, instead of the asset proof or a bank statement, you're much better off uploading something like the tax return or tax transcript, because it's showing the the full past year and what happened. Obviously, you can also attach stuff like, for example, if you lost your employment, for example, maybe you're receiving unemployment benefits, or if because of the financial hardship you're receiving some kind of public benefits, like for example food stamps or maybe Medicaid or something along those lines. If that's the case, then this is going to be a much better proof, corroborating evidence, rather than just the bank statement. Because you have to understand that whenever it comes to the bank statement, people can have two different banks, and in one bank they have hundreds of thousands of dollars, and another bank they have, yeah, $10, $100, and then they show and it says, look, I don't have any money. Something along those lines. But you cannot do this with a tax return, because tax returns shows everything basically. And then obviously with the public benefits, you can't trick it either, because, well, you're not going to qualify for public benefits if you don't show all of these documents. All right, let's move on to our last question for today from Amanda Bruce. Amanda Bruce says, I am documentarily qualified 2022 November and 6 months passed and no interview letter. What to do? Amanda, please let me know what the category you're in, because if you are, if we're talking about immediate relative category and the immigrant visa is already available, then 6 months, yeah, normally it takes about 6 months to get the interview scheduled. But I've seen, personally in my I-130, for both of my parents, it took 9 months. So, that's the longest I've seen, because for most everybody else, it was around 6 months. But again, if you are not in immediate relative category, if you are dealing with the visa backlog, then it might take much longer, because after you're documentarily qualified, a lot of people they're already documentarily qualified and they're still waiting for their immigrant visa to become available, and it can be like a year, 2 years. I wouldn't say 3 years, because usually NVC portal, they open up closer to the availability of the immigrant visa, and most of the times it's about a year and a half. But still, if you can come back to this channel and let me know what category you're in, I might be able to give you a little bit more information. But if you're in immediate relative, if you know that your immigrant visa is already available, what you can do is you can actually reach out to the U.S. Embassy that is in the country where the beneficiary is, and ask them, say, hey, the immigrant visa is already available. I'm in immediate relative category, already documentarily qualified. It's been 6 months and the interview is still not scheduled. I was wondering if you can give me, approximately when my interview is going to be scheduled. And sometimes they say, no, we can't give you that information. But I've seen cases where they actually look into their scheduling system and they tell you, because they can't officially send you an interview notice longer than 30 days before the actual interview date. So let's say if it's scheduled for September 1st, they can't send you the notice that the interview was scheduled for September 1st up until August 1st. They need the 30 days, so that it's within those 30 days you do the medical examination. That's really the point of it. So thank you very much, everyone, for asking your questions. I really appreciate your time. Hopefully my answers were helpful. If you have any follow-up questions, comments, let me know. Just post them, as many questions as you have. I am grateful for your trust and into this channel and into the information that I provide. So thank you very much. God bless, and I will see you all in the next video.